was easy when I started.
Oh, that was
It was really hard to do.
it's a hot topic.
'Cause you have to
Well,
meet
I'd
with
already had
people and
all the news stations out
meeting
there
somebody
like
at
a
going to shops.
couple of months earlier because of a death
Maybe other
penalty
finances.
case. And so they all knew my house.
Thank you.
Cute.
We're gonna get an agenda.
So you're advertising that shirt no matter what, huh?
Well,
Thank you, Bobby.
20 minutes
You
ago.
know, I'd still like to do something about Annie. I don't know if it means writing a letter to the commissioner saying, you know,
I don't understand the whole process.
somebody.
Okay.
Wasn't it?
I have the one I got in the email. Okay.
Necessary. Yeah. That's how most workshops are done. It's even citywide. Yeah.
This is it. Call us here for this?
I
Couldn't
believe
we have
that
done this in a bar?
Well, now, wait a minute, you
give
didn't
it to
say
Todd.
anything about homework.
Homework.
Homework?
Homework.
God,
Yeah, really?
I'll start having nightmares again.
You got that right.
Can't remember my locker combination. And I'm naked from the waist down, you know, those bad dreams.
Got it? I don't know if he's taping or not, but if he is, it's on record.
There you go. Whoa.
Okay.
Somebody knocked over the video recorder.
They're working on the roof.
I have squirrels that I feed, but the acorns have been so big this year that for the last month, it's like I've had a basketball tournament on the roof of my house.
Really?
I mean, it's loud. Finally about gone. My dog gained 10 pounds one year because I didn't have enough squirrels and he was eating them all. It is. Got him on a green bean diet. It's all back on.
I want one.
Okay.
Thank you.
Thank you.
Some of them.
Okay.
I'm not gonna get one. I'm gonna need one.
I'm going to call this work session of the Code Enforcement Board of the City of Tarpon Springs to order. If we could please have a roll call.
Mr. Selesky,
Here?
Mr. Demasas,
Here.
Ms. Vacacy,
Here?
Mr. Kramer,
Yes.
Mrs. Archer. Here. Mr. Chivry,
Here.
Mrs. Allen. Here. Mr. Bergman,
Here.
Mrs. Dabbs. This completes your roll call.
Thank you. I guess we're just going to turn it over to you now, and we're going to discuss what we have here as far as the agenda concerned.
You want to get to a mic, Steve? Yeah, I think it'd be best so everybody can hear better. And get it on the tape, but they're taping it upstairs.
Anybody up there? I don't think so. Oh, yeah, he is. Okay.
You waving?
Yep, we're on tape.
All right. You should get one of those little wireless ones because I walk around and talk with my hands really well. This sitting down thing drives me crazy. So y'all
Sit
know.
down. Let's
Can y'all hear me okay?
Yes.
All right. I appreciate you doing this. As you guys all know, we lost, well, not lost, but Sue went over to the fire department, so I don't have a clerk, which significantly affects our hearings because I have yet to learn how to do those. There's a lot of stuff that goes with putting a hearing together, all the paperwork and everything. So we're in kind of limbo. They haven't even posted the position yet. So with that being said, there's more than a good chance you guys are going to be off in January. So at this point in time, it looks like we're probably not going to have code board in January, which is the 12th, correct?
Yes.
So with that being said, unless something drastically changes in the next week, and we'll put out a formal notice that there will be no code board, but just a heads up, more than likely, we're not going to do it next month. So with that being said, the reason why I asked to kind of do this workshop is I'm new to this. I've been a cop for 24 years. Code enforcement's a little different. And as Jay, who works with Tom, can tell you, they keep sending me to classes, which drives Jay crazy because I come back with all this new knowledge and I go, ooh, I can do this and I can do this, which kind of rolls down to you guys, because you guys as the code board are what empowers the knowledge sometimes that I have, procedurally especially. What I handed out to you was Florida State Statute 162. It's not the whole statute, but it kind of is a summary of what's really important and what governs not only the code board and what they legally are allowed to do, but also what a code inspector is legally allowed to do. Even though I'm a police officer, I still am a code inspector, and code inspectors have certain duties and rights and legal things that we can do. And one of the biggest things to understand is I still work under the United States Constitution for everything that I do. And what that basically means is the Fourth Amendment, which is the unlawful search and seizures aspect of the United States Constitution, means that there's certain things I can't do. I can't look over people's fences. I can't traipse around in their backyard. I can't fly a drone over somebody's house to see if there's debris in their backyard. And I want you guys to kind of understand that, because you'll hear me a lot of times, and you've probably already gotten used to where I start talking about, I want to enter it into the record. I want to preserve it for the record. Because part of this learning process, I figured out that the backside of you guys, which is the appellate court, the way they handle appeals is strictly what's introduced into the record. If we don't put anything into the record, the appellate court really has nothing to look at. They don't interview anybody. They strictly listen to the tapes, and Tom, correct me if I'm wrong, but they listen to the tapes and they review the paperwork. And for the most part, that's really it. So partway through, you guys noticed I started to introduce a lot of evidence. And the reason why is to preserve that record so that we have a good record. And I learned through many years of law enforcement, you're always better off having more than not enough. So I wanted you guys to understand that's the reason why there's so many exhibits now. That's not going to change. I don't think I'm going to be adding any more, but we're pretty much leveled off with that. If you guys have any questions about that, or if you think you'd rather have other stuff added, I'm more than happy to do that. I want to provide you guys with the most information to make the best decisions on behalf of the city. So that's part of one of the things I wanted to touch base with, and I kind of already did. And the other part was just so you guys kind of understood the statutes and the rules that I have to work under. And those are the same rules that you guys have to work under. And I don't think by any stretch that we're doing anything wrong. There's a couple times I've noticed where questions get asked that are kind of outside the scope of what we're trying to decide. And the long and short and the simple of what we're trying to decide is, was there a violation, first off? And is the person or group that's here the violator? And that really is the long and short of it. The intricacies kind of come at the end, and it's similar to a criminal in a way that you kind of decide, did the offense occur? And then you look at the personal factors sometimes on the tail end of it. It's like that first thing, are you the person that's in charge of it? Are you the violator? And did that violation occur? That's the first step. Once that's decided, then there's all the other moving parts. I'm going to segue a little. I'm going to kind of breeze through this list and not just sit here and hammer on each point, because they all kind of bleed in together. And the reason why I bring that up is there's an aspect I'd like to consider the board to switch to when we're deciding cases, or when you're deciding cases, and that's a guilty phase versus a penalty phase. Currently what we do is we hear the case, and you guys make a motion that so-and-so is the offender and he committed the offense and he's got 30 days to take care of it, or we're going to charge him $50 a month or $50 a day. What I am respectfully asking the board is to consider going to where the first part is decided, are they guilty? Did the violation occur, and are they the violator? And the reason why I'm asking that is I want to introduce prosecution costs into the board as part of the penalty aspect. And I would also like an opportunity to possibly recommend either a fine or, as you'll read in this statute, and again, I'll refer back to Tom a lot because he's done this longer than I think I've been alive, but no offense, Tom, you're not that much older than me. But he's been doing this longer than I've been a cop, I can guarantee that. So I don't want to go too far off, but the code board has the ability to order certain things. I don't want to give everybody the impression that suddenly we can run around and tell people they have to tear houses down and things like that. There's still an abatement process. The city manager, I think, still has to get involved and sign off. But the board does have the ability to order things. We can't talk about specific cases or anything, but you can imagine there's been times where I've seen the questions and kind of the wheels turning about, well, there's this pool that nobody's doing anything about, and we're just going to fine them X number of dollars a day until they fix it. The board can order certain things to occur, and that one of those things that could happen is the board can order that pool or the whatever be covered securely, a contractor be hired and it be taken care of. That's covered in the statute and it's allowed by the board. That's an avenue that you collectively have in your penalty aspect. It doesn't always have to be a fine. Obviously that's kind of the wheelhouse we're used to working in, but it doesn't have to be that way. You can, they say up to and including abatements, but I don't even want to go down that road. So I'm handling that a different way. But you certainly do have the ability to kind of think a little bit outside of the fine box in that regard. So with that being said, the other aspect, and I'm going to pass out this other sheet that I would like to start presenting if the board has no significant issue with it, is prosecution costs. This is not a real case. It's all zeros, so it's not reflective of anything. But there's a significant amount of time and expense that goes into bringing a case to board. There's paperwork costs, there's clerical time, there's even equipment, my time, and under state statute, we are allowed to request prosecution costs, more or less prosecution costs. They're the costs of doing business that are outside of the normal, just doing my job. The city taxpayer dollars pay for a code inspector to go out and do certain things, but bringing a case before the board, as you can see, this is a reasonable example of a simple case. And those are reasonable costs that are applied to that. The postage, for example, on certified mail averages anywhere between $6 to $12 to $14, depending on the size of the envelope. In some cases, we send out 2, 3, 4 notices for one property. So it does get a little bit expensive. And the thing is all we ever want is compliance from these folks. I send them courtesy letters. I put door hangers up. I then send them notice of violations. I then send them final notice of violations before I bring them before the code board. So we've made a significant effort to try to resolve this issue before I have to have them come before you guys and hear this case. And for that reason, there's an expense that goes with that that's burdened by everybody. And in fact, it should be burdened by the folks that are violating the ordinance. So with that penalty and guilt aspect that I'm asking for, and I don't know how it's going to affect the motions, but if we choose to go that route, the motions might have to be slightly changed and just broken up, and this is where I'll refer to get some help from Tom on how to actually word it, is that, are they guilty? Are they the violator, and are they guilty? And when that motion's been decided, I would then present the prosecution, because obviously if you don't decide that they're guilty, we're done. Have a nice day, see you later, bye. The moot point. But if you do, then I would like the opportunity to present these prosecution costs. The only time I'm going to be presenting them, obviously, is code board. They're not going to happen on notice of hearings and then they take care, notice of violations and then they take care of it. It's only before the board that I'm going to have these prosecution costs, or what I'll call the administrative fees. So with your consent, and it'll probably now be February, and I can work with the chairman or however we have to do it to modify, because I know you have standardized motions. So I think the motion would just basically be, the motion on the floor is, are they in violation? And are they the violator? And then the next aspect of the motion is, the penalty side of it.
Guilty or non-guilty. Guilty or non-guilty, and then
basically guilty or not guilty, and then the penalty side of it. I would like the opportunity to suggest, and I'm not going haywire, everybody in the world's not going to get a $250 fine and things like that. My biggest impact will be the prosecution costs. Beyond that, unless there's some extraordinary circumstances, because that's when I would normally bring up the prior cases. In criminal cases, you can't bring up somebody's history until they've been found guilty. So in some regards, this is quasi-judicial. It does follow some of those rules of law, and we sometimes talk about a person's history, but it has nothing to do with whether or not they committed the offense. So it really should only be considered at the penalty aspect of the case. The fact that the guy didn't mow his yard 14 times before doesn't mean is his yard mowed now. Do you follow me? My logic with that? Everybody's allowed that opportunity in the United States in the court system. Now, when we find him, well, he hasn't mowed his yard. He's before the board. You all decide he hasn't mowed his yard. Now we look and go, he hasn't mowed his yard 14 times. He's a repeat violator. He's been before you guys 6 times to deal with this. That's where, you know, the court uses point system for criminal violations. Oh, he scored enough points. He's going to prison now. Same thing can apply here. You have a sliding scale for fines. You have a sliding scale for certain things that can be done. My opinion is that's when that history should be applied. I'd rather not introduce it at the beginning because it shouldn't sway you guys in any way, shape, or form as to whether or not they're guilty of the violation at the time. That make sense?
Yes.
And if I'm insulting anybody's intelligence, please let me know.
I think you're actually preaching to the choir. I think if we knew this is what it cost the city to pursue a situation, I don't think anybody'd have a problem building that into the fine, you know, making it, okay.
Just me. Oh, sorry, go ahead, Carl.
All right.
I don't have a problem with it. I actually agree with it, but the matter of which it's being entertained right now, I do have an issue with. I think you first have, I would assume this should go in front of the commissioners, first of all. They should be aware of this. And the people that really need to be aware of this is the community. If you're going to evoke a penalty phase like this for whatever, not cutting your grass, and you have to go out there multiple times, I can see costs there. But I think that you have to inform. You have to inform the community that this is going to happen if you don't do this from now on. And that's just the way I have to look at it. You know, I can't, I would be very upset if I was on the other side and I came in here for a hearing, me not cutting the grass after 3 weeks, and then all of a sudden I find out that there's also a prosecution cost. Where'd that come from? You see, I think you have to almost inform.
Well,
but I do agree with it. Okay.
Right, and maybe in there's 2 parts. I can tell you in the statute it's allowed. Yes, there's a lot of things in the statute, and the ignorance of the law is no excuse, yada, yada, yada. The other thing is those letters that I send them previously that are attached to that packet that I turn as evidence clearly states what their fine is up to, what they potentially could be faced with when they went to code board. They have been informed of the potential. The notice of violation states, also including administrative costs. And I don't have a dollar value on that. The dollar value, like this particular non-existent case that I did, it documents 3 inspections. That's my initial inspection. That's me going out after I send a courtesy letter to them, and then actually it probably should be 4, and then sending out a notice of violation prior to the notice of hearing. So I usually do about an average of 4 inspections where I go by and take pictures and things like that. So that's where it comes in. It is included in the notice of violation. It is included in the notice of hearing. The only one it's not included in is the courtesy letter, because by law, I'm not required to issue a courtesy letter. We do that strictly as a courtesy. I also use these little fancy green door hangers. I'm more than happy to swing by all y'all's houses and hang one on your door for something if you want to see what they look like. But that's another avenue I use. One of the reasons why I work Saturday is I try to make personal contact with everybody. I don't use the technique of, well, if you don't do this, I'm going to take you to the evil code board and they're going to fine you and they're going to do all this stuff. But Manny, they're given some significant information prior to sitting before you.
And 30
This
days
is,
at least to
you guys are
fix it.
the end of the road, so to speak. It's gotten to this point. And it's usually, for whatever it may be a minor thing, mowing grass, or it could be a substantial thing where the building is falling down and the neighborhood kids could die. I mean, you know what I mean, to the extremes. But there's been a significant path that we've traveled to get to this point.
I'm glad I don't know that, first of all. But don't you think it'd be more of an inducement if the numbers were actually on that letter? You know, if I have to come out here again, it's another $90. But if we do that, okay, if we do this, they have to pay the fine. None of this that, you know, we waive that right, no, it's all right, no. They have to pay the fine. We either do this or we don't,
I don't have a problem with it.
you know?
And but I think, I agree that perhaps it'd be good to spell that out and say, at some point in that letter, quote, that an estimate of the.
We could certainly do it at the
administrative
notice
fee
of hearing time, because this is based on, I'm preparing to post their property, I'm preparing to bring the case to code board. This exact sheet of paper can be attached to their final letter.
In other words, so that somebody knows, geez, if I don't finally, after the third time, you know, however many contacts, if I don't get off the dime now, I'm gonna have to go to code enforcement, and I've already facing $185 in expenses. I personally think that the city is certainly entitled to regain any money that they spent in all this effort, because all we're trying to do is to get people to make the city livable for all of us.
Correct.
So if somebody wants to disregard that, I think that eventually they should have to pay. Okay, so I don't think ethically or morally we have a problem with it, but I think that if it's spelled out to them, now the person's really a dumb nut. If he or she comes in, okay, still hasn't corrected the situation, okay, and they know that they're facing not only a fine per day, but they're also facing that these are the administrative costs.
Yeah, I can certainly, like I said, the notice of hearing letter can be modified. I now know how to do them. They
I
made
just
the
don't think
mistake
it
of showing
should be
me
a
how.
surprise, and I agree with you that.
And I can certainly attach, this is an Excel spreadsheet where all the prices are all fixed. The costs are all fixed. All the clerk does is go in and throw a quantity into it, and it does all the math for you. I print it out. It's got the case number on it. I intend it's going to be an attachment that goes, but you won't see it on the case. If we split to guilty penalty aspect of handling our cases in the future, you won't see this until you've decided that the violation occurred. And then at that point in time, I'd say I'd present to the board the violation costs, you know.
But the offender will.
The offender would get it.
will
They would be
receive
aware
this.
that these are their administrative costs. And Tom, you don't see an issue with that at all, do you, going out with the, I know that we're allowed administrative costs in the statute.
Yeah, you're also entitled to it pursuant to the ordinance that passed 20 years ago in 1996 when I drafted it the first time. So the public has had notice of it for over 20 years. It's just the exact dollar amount is the question. Some cities don't do it at the original hearing. Some cities do it at the compliance, non-compliance hearing. For example, Safety Harbor will bring in an affidavit of compliance or non-compliance. In addition to that, they'll ask for a motion to be made to capture the costs that have been incurred. Because at the first meeting, you're only capturing the cost through that point. You don't actually capture the cost for the second compliance, non-compliance hearing. That would have to come back to you a second time. So some cities do it in one fell swoop at the compliance, non-compliance hearing. That's what my suggestion is you would pick up all of your costs and at one time instead of having to do it twice. Either that or do it one time in the beginning and you just understand that you're not going to capture.
Well, let me ask you this. Would we always do our affidavits of compliance and non-compliance? Obviously, compliance is done. I mean, it's a done deal. But the non-compliance ones, for example, some of those, I conduct an inspection every 3 months. And I've been doing some of them. I've already done some places 9 times because they're out of compliance. And that's going to continue on because I'm legally required to continue to inspect these properties. So from what they may never come into compliance when we also wouldn't attach those costs, but we're attaching daily fines to them. And I agree with Tom. And if the board's in agreement with that, simply what would happen is when we present the affidavits of compliance, there'd be one more aspect is in accepting the affidavit of compliance, you're also accepting the prosecution or the administrative costs of X. And we'd introduce this document at the compliance time and then it's put into the record. Is that? You can do it either way. I understand your concern on a non-compliance hearing that there will obviously be additional costs past that. And I'm just trying to pick up those 2 hearings. We know we're going to immediately come before the board. Correct.
My suggestion is that you capture, whether it's compliance or non-compliance, you capture it at that second hearing.
Okay.
And then obviously, if it surprises me that you're out there doing inspections on these things without being called because most cities don't do that. It's a lot of proactive work on your part But most cities don't do that. They'll wait for the call. And therefore, you would only have the one inspection when it's in compliance again. So, but whichever way the board wants to do it or you want to do it, it's your case. You can present it at any time that you want, and the board is going to have to consider it when you present it. But we can work on the motions to make it a little bit easier in this transition as to how the motions will read, so the board members will feel a little bit more comfortable with it.
Well, I agree with Tom. I think definitely at that second aspect, and even if they go into non-compliance, we can always present additional costs later down the road when they do come into compliance. So hypothetically, I present this for a non-compliance when we have the affidavits of non-compliance, and they're up to X number of dollars. That's ordered by the board and it's attached at that point in time. I do 5 more inspections or whatever the case may be, and we have another hearing or whatnot. I would present at the affidavit of compliance those additional 5 inspections, and they would just be the additional cost that's added on the end. If that the board agrees with, we can certainly do that at that second aspect. It doesn't change. I would still prefer to go to the guilt penalty aspect, and we just leave the administrative costs out at the initial hearing, because in that penalty phase is when I would prefer. I've always felt uncomfortable presenting history on somebody, and that's probably just because I've been in the criminal court for so long. I didn't like you could never bring up anybody's history to decide whether they're guilty. It could only be used as a penalty. And I think it's more influential and more effective for the board because we've all done it. We've all sat here and went, God, this guy just never mows his yard. And dang it, he's gonna get the $250 fine. But does it make you think that because he hasn't mowed his yard 14 times, did he mow it this time? And that's what I want to avoid. And I think it makes it easier for the board as well, because you're not being swayed by historical information. It is, and then if an appeal occurs, there's not going to be an issue where you were swayed by me presenting a history and all these things that really couldn't be considered if he was the violator and did the violation occur. It's those simple 2 things that have to be decided by the board. And then the rest is just the penalty aspect. Does that sound reasonable to everybody? Are we okay with that, or do we have go a different direction, or just stay what we're doing and we move on?
Are we gonna have some reworking of the script as far as the
Yeah,
way the motions are worded?
I'll work with the city on getting those motions reworked so that you're comfortable with the language of those motions and make it a little bit easier, your job a little bit easier. Most city boards do that so that you don't have to think on the fly. And frankly, after you do it a number of times, it's kind of becomes secondhand nature, and you're kind of like filling in the blanks as you're on the move. One thing I did want to mention to Officer Gasson is that on this presentation of the prosecution costs, I see it happening one of 2 ways. One is by affidavit.
Okay.
So if you list it by affidavit, you're going to present those affidavits like you do an affidavit of compliance. Otherwise, and I think that is the better way to do it because it's less time consuming. Otherwise, you're going to have to testify that you went out there and did 3 inspections, that you did a courtesy letter and it cost $15 to send it. Then you did a notice of violation and did $15 for that or $25 for that. And you have to go down through this long list. And I will tell you that the courts, circuit court, county court, whatever, when they consider costs, they consider it in an affidavit form, cost affidavit. And so you can do the same thing. That's what my suggestion is. He's swearing under oath that these are the costs incurred in the case. And so that has some credibility to it. Otherwise, he needs to do it here in front of you. I swear under oath that I had these costs. So that's a suggestion. We can work on a form affidavit for you to do and fill out these exact dollar amounts. One thing I would suggest that be careful of is that we don't get, we generally spend this amount of money on each case. It needs to be specific for each case.
Yeah, and that's why there's the number of inspections. The courtesy letters are a different cost than notice of violations and hearings because they're simple mailings versus complex mailings, if you will. And the affidavits of compliance and non-compliance are different. And that's kind of how I was explained. Yeah, you had to individually, you couldn't just say, my costs are $200. Yeah. You had to be able to break it down. And I agree, it'd be much easier, and I can certainly make this affidavit language around the table inside of it and swear that out and attach it with either the affidavit of compliance or non-compliance.
The other thing I would kind of jump in here and say, when most cities, they do this, they break down the time spent by the code inspector and then the mailing and then any other out-of-pocket costs. I have not seen it where you have courtesy letter, $15. Is that the time that it cost for you or your staff member to prepare that letter? Because if it is, my suggestion is that you designate that is the labor cost involved and not out-of-pocket cost.
Understood.
Yeah.
Somebody's gonna say, geez, it only costs 50 cents to send a letter.
Where's 15?
Yeah, I mean, I keep track of when I do my cases, there's a time, the amount of time I spend on it. So it's easy enough for me to convert this to a quantity of time at this hourly rate presents this amount.
And it may
mathematically
be
will still work
a
out.
different rate for your support staff
Exactly.
doing all the paperwork versus your rate doing the inspections. And if they only charge, obviously $25 an hour is not going to cover your cost expense. That's probably something more significant than that. But I would ask you that for the purposes of this board and for appellate review is that number is not going to stay consistent year to year. Whenever the costs go up, your hourly rate, for example, goes up, then that hourly rate would go up.
Understood.
And have something that you can associate it with.
I can do
Yeah,
that.
but we're not asking for the citizens of this city to pay for his cost.
Yeah, we are.
Not really, because he already has the job.
It doesn't matter, because he could be using that time that he's got doing something else for the city. That's the reason why the code was changed in 1996. That's why the state statute requires it to be done. They all understand that, that we're reimbursing the city for expenses incurred that derived directly from that person's inability to take care of his own matter. So that's exactly what it's for.
Yeah. Had you mowed your lawn, we wouldn't have to get involved with you.
No, I agree, I'm just
And Manny,
wondering why
understand-
that wasn't done in the first place. I mean,
Well,
you know?
I think some of it was, unfortunately, like I said, they sent me to classes, so I learned. I've talked to some other people, some other cities, and realized, to bring a case before you guys, and if I did these numbers based on what Tom is saying, based on my hourly rate, they're going to change. There's a significant amount of time put into this before you guys ever see it, and now we're washing all the rest of it. For anybody that doesn't appear before you, I currently am holding 52 open cases right now by myself, just me. I'm the only guy in town, and I have 52 open cases. None of those cases have less than 3 inspections on them. 85% of those cases are going to clear, and you're never going to see them. But I still did all the stuff with them. We still did all of this except for the notice of hearing, and so there's still a significant amount of time, and that's why I specifically found out that yes, we are allowed, and it is. I want compliance. That's all I want, and I would prefer nobody ever came before the board, and I try for that. And if that influences somebody by a notice of hearing, tell them your potential costs,
I think
administrative costs could be $225, regardless. The only way not to have those is to take care of the issue before they stand here in that seat before you. And that's the long and short of it, or if they're found not guilty.
how do we treat people that are out of state and maybe they don't get the letter, or we have trouble contacting?
Well, that you actually segued into a perfect thing. That is another thing I wanted to discuss with you guys, and I'll lean into it a little bit. Is one of the biggest things that happens to code board cases that they're fought in the appellate court, from my understanding, is due process. That's them bothering me while I'm at work. Is due process, and I learned really quickly the reason why we're doing all these certified letters, and the reason why we're finding, by law, we're required to find the registered agent for businesses, and we send out 4, 5, 6 letters to everybody in the world that's related to that property, is to satisfy due process, which is another thing that's covered under the United States Constitution. And reading through case law and some other stuff, a lot of code board cases are lost because the person didn't get notified. And Sue did an amazing job, and I'm hoping that whoever I get and myself is able to continue her aggressive approach to making sure people are notified. The reason why I sit before you guys and explain, I sent it to the property owner listed by this database and this database, or to the registered agent, and I got a return receipt, is for that purpose of due process, to make sure that they did get notified, they did get an opportunity. The other aspect that you sometimes the board necessarily can't appreciate is, I love email, as you guys already figured out, because I asked for everybody's email address. My letters have my email address on it, and I communicate with these people. I give people time. They call me up and say, hey, I need some more time. I give them the time. You know, that's what I don't want to bring cases before the board. My goal I would love to have, other than January where I just have to ditch and we can't do it, I would love to have a month where we literally don't have any cases because everybody complied. And I try very hard to get them to comply prior to ever coming to the board. So, and I'm very serious about due process. And sorry, go ahead, Tom.
Yeah, let me just jump in here. There's three things. When cases are appealed to the circuit court, you know, there are a lot of different court levels. You have the county court, which is things of value up to $15,000 being sued for. Then you have circuit court, which is the value of over $15,000, and then certain other matters. Certain other matters include appeals from quasi-judicial boards, like Code Enforcement Board, Board of Adjustment. So when that appellate court gets the case, they look for only three things. Has due process been given? That's where a lot of cases have been lost because of the fact that they weren't served through green card, the property wasn't posted, or it went to the wrong place because, you know, the statute wasn't followed. That's due process. The second thing is where the essential requirements of law followed. So did you apply the correct law when you made your determination? So, for example, if he cited you with high grass, junk, trash, and debris, and you found him in violation of failing to have your address number on your house facing the street, well, then you haven't followed the essential requirements of the law. And the third thing is that the court's looking for, is there substantial competent evidence for you to have made your decision? So if he gets up there and doesn't say one word about the high grass, but you find him in violation of the high grass, well then, you know, you haven't met, there is no competent substantial evidence for that finding. So that's what the circuit court is doing. And I will tell you, over the last 20 years that I've been doing this board, there have been 2 or 3 cases, and they're the oddball cases out. But I don't think we've ever lost any. But what Steve is, you know, talking to us about is these are the reasons why we do it. And that's, you know, and we don't have these frank discussions with the board all the time when we have an audience full of people, because it frankly is just not appropriate at that time. But those are the things that we're looking at. That's what he's trying to present to you. Every city does a little bit different. Steve's doing it. He wants to make a couple of changes here, and I think that they're absolutely appropriate. But really, you're the judge and the jury. He can present the case any way he wants. He's kind of being upfront with you, saying, I'm going to change the way I present the case to you, and I want you to feel good about it, kind of thing. But he can present the case any way he wants to this board. He just wants to make sure that you understand, you know, the changes that are being made. So.
What? You have a question?
Annie, did you have a question?
Yes, trying to understand the administrative process, because the city already has an administrative office. Am I correct for this code enforcement? So what I'm trying to understand is, here with the prosecution part, will that somehow be presented to the guilty fine, or is that to be added to the administrative cost? Because in the administrative cost, all these letters, everything comes out of the administrative office.
You're correct, but as Tom stated, statutorily in our own ordinance, we're allowed to pay a significant amount, and it's kind of akin to that. That same thing, this is over, and you gotta understand, like I said, this is only cases that come to you guys. Out of my 55 cases, I might have 5 that you guys are gonna hear. If I'm lucky, I might have done 1. But that's my percentage. I'm at about a 95% closure rate. I guess if I was state attorney. But, you're right. That's what I'm trying for. And the thing is it's, I'm not trying, this isn't a penalty per se. This is not inducement to get them to mow their yard. This is reimbursing the city for extra-central costs of bringing you before the board. The penalty is still the penalty. This is outside of it. This isn't, well, I'm gonna charge you $225 in cost and $50 a day. Now, your penalty is $50 a day. With that, there's $225 in cost related to bringing this case before the code. So that's kind of the thought process. At least my thought process, at least.
Yeah, and Ann, I think you mentioned administrative costs. It's not really an administrative cost because, as he stated, it's a code enforcement prosecution cost.
And I'll probably change the title of the prosecution
But
sentence.
am I correct in thinking that way? Once it gets here, it actually becomes a prosecution cost, right?
Correct.
If you go out there for 2 times and the guy takes care of it, it's no problem, right?
This doesn't exist at
Okay,
that point.
right.
This is solely to bring a case to code board. These are the costs of doing that to here.
Right.
It's the same as somebody else. I get arrested, and I tear my pants, and I charge $55 an hour and whatever cost, and then the case is dismissed. We don't ever get those costs. They only happen once they're convicted. That's the exact same thing that occurs here. Once they're found guilty by the board, that's when we move on to that. So
Steve, this is already in the ordinance to add these.
Mhm.
It's
yeah, I'm not doing
permissible by
anything
the ordinance.
wild and crazy.
I think what we're looking at here is how do we structure it? You know, it's easy for us to say the fine is $50 a day. We're gonna have to add $50 a day plus $225.
Well, actually, as what Tom suggested, and that's the direction I think I'm going to go, is at that second hearing when you guys are approving. Right now, you blanket approve the affidavit of compliances. I've got 7 affidavit compliances. I got a motion to approve all of them. What's going to change is the affidavit of compliance for 123 Main Street would approve it. And are there costs that will go with it? Yes, sir, there is. I presented an affidavit for costs of $200 for 123 Main Street, case number XYZ. Do you approve both the compliance affidavit, and I think I'm going the right way because Tom hasn't given me the one eyebrow yet, and then we approve the costs as well.
Wait a minute, now you're saying that somebody's complied and we're still gonna go after the cost?
Yes.
Well, after they've
If
been found
they
guilty.
came to you, they came to the board.
Oh, okay,
Yes,
all right.
this
all right.
is
This is a
this is
month
only
later.
This is
only
later.
board
All right,
cases.
okay. All
I'm
right,
not
that-
doing this with
I got
anybody
you.
that does
All
not
right,
come before the
okay.
board.
This is not a case that hasn't, this is a case that we heard and now
Yes,
they're
sir.
in compliance.
Yes,
I
sir.
got it. All right, that's fine.
That sounds more manageable here.
Yeah, it's all you guys. Nobody is ever going to see this sheet if they don't come before you.
That's fine. I
That make
got it.
sense?
Yes.
So the,
We'll just have a hard number on that, 225 or whatever your number is. And as the attorney points out, that'll probably change as time moves on.
well,
That's
it'll be
fine.
different for every case.
Yeah,
Because he may only do one inspection or one for
Yes.
one case, he may do 10
Yeah.
for another. But, so the motion would be something like, I move that to approve the affidavit of compliance and the affidavit of cost in the amount of $200.
does that mean I don't have to do them anymore?
Well, no.
No, you, I mean, your
We're
role
gonna
is
still look for you to do
expanded
that.
now.
You
got a bigger
off the hook
role.
for that.
I get paid more too?
Absolutely.
You
No question.
You're gonna double your pay.
That's it.
All right. So the
Very generous, Mr. Attorney. He's gonna
You
double
just
my
carry an
pay.
ATM machine with you, that, one of those handheld ones would be
Yeah.
nice.
Okay,
It-
I like that way. That's much more
yeah. So
manageable.
this is the extreme. This is the 5%, the 2% of all the cases that I handle in the city
Right.
that are ever going to have these costs added to them. So.
Okay.
The other aspect, the other thing that I wanted to discuss briefly, and it's covered in statute, is that owners are not necessarily always the violators. So a property owner, typically we always think of as the violator, but it doesn't necessarily have to be a violator. A perfect example of that is I arrest somebody for an open container. I don't cite the property owner. I arrest the guy for open container, which is an ordinance violation, but because I'm a police officer, I can actually arrest for it. Another example is sometimes with abandoned vehicles and things like that, we usually cite the property owner, but a lot of times the owner of that vehicle is actually the one violating the ordinance. So you may see where a case is presented before you that the property owner may not necessarily be the person before you. It very well could be the violator. In 99% of the cases, the violator is the property owner. Or we can, in most cases, tie the property owner back to some ownership responsibility of the violation. Sorry, go ahead, Jordan.
So to simplify it, I own property, but I'm renting it out. My renter is in violation, so he would be the one coming in front of the board, or still me because it's my property and I'm responsible for it?
Ultimately, yes. That's the easiest path. That's the path of least resistance, is to cite the owner. We send those letters to the tenant. So say you own a property at 123 Main Street, you live in Poughkeepsie, New York, we send you the letter, but 123 Main Street gets a letter too.
The letter also.
And they get a certified letter, both places. So this is what I'm talking about with the costs.
Okay.
You know, now one goes to both places. So the tenant's been cited. Ultimately, it is a property owner, but there may be cases where I'm only bringing a vehicle because it's owned by somebody and it's on residential property.
Oh,
So I'm just
okay.
saying, if
So
you
you
see
would be
that,
bringing
it
in
doesn't
the-
always have to be the
You would be
property
bringing
owner.
in the owner of the vehicle,
vehicle.
not per se the owner of the property.
Correct.
But in your presentation, you're gonna make it clear
I'll make
as
it
to why they're
abundantly
there.
clear. Yes,
So
sir.
we don't, you know,
One of those things cropped up over the last few months. It just was one of those things I wanted to make sure in the last class I went to, wanted to make sure that it's not always the property owner, because under statute, it says violator. In most cases, the violator is the property owner.
you tell us, we'll
Especially-
believe you.
So, one other thing that over time, and we've had a couple people that have actually asked Sue after a code board hearing that I'd ask, and Jerome, this probably is going to go more towards you or whoever happens to be the chairperson, is kind of a brief synopsis or summary of what the person has to do, the violator. If they're found guilty and there's a fine assessed and they have a certain period of time, and maybe you order a this or a that or a, whatever, is to concisely say, okay, Mr. Johnson, you understand that by January 17th, you have to take care of X, Y, and Z, or the city is going to fine you $50 a day starting on January 17th until you take care of it. And then at that point in time, you have to call the code officer. He's going to come out and he's going to inspect it. And then the fines will stop and you'll have another hearing.
So more or less summarize
Summarize
what we, okay.
the penalty. It's kind of like you go to traffic court, which none of you have ever been to traffic court because nobody's ever gotten a ticket. But the magistrate explains, well, I found you guilty. I'm going to send you to driving school. Your fine's going to be $166 and $40 in court costs. You got 30 days to take care of that. Do you have any questions? And that's kind of what we've had a few people kind of complain about, is they're like, well, what am I doing now? And I don't know, from a clerk standpoint, I know Sue gets a lot of phone calls like the next day and go, what just happened? So I'm asking you or whoever happens to be sitting in the chair position to just kind of summarize that case and make sure the person understands all the penalties and all the things that have occurred with the code board. So, and that's just an observation,
Oh, I agree, because sometimes they don't
Okay.
even know the case is done, and they're still sitting there, and, we're on to the next case, so I have to wrap it up.
The probably one of the only other things that I would bring up is, and I know it's difficult because everybody lives in the city, and this is where the difference of special magistrate versus code boards kind of come in. I know some of you folks see people that have probably been to code board, or you went to church with them, or they work at your restaurant and you're hoping they don't spit in your food, because that happens to me all the time. I only go to places where I can see them cook my food. With that being said, I understand sometimes it's difficult to find folks. And where I'm going with this is I've seen a couple of occasions where initially the person was brought before the board and the penalty was $100 a day. You get $100 a day to take care of your yard. Then I do a repeat violator on him, and he shows up here and he's been out of violation for 5 days, and it's $150 a day. Well, 3 months ago, you guys, it was $100 a day, and now he's a repeat violator. He's already ignored you 3 months ago. This is that history aspect that I'm bringing up. You guys obviously can do whatever you want, but it seems a little odd that 3 months ago, we were going to charge this guy $100 a day for the exact same offense that he's now ignored and let go for 5 days. And now we're going to charge him.
But in all fairness, is it on the record clearly? Because I can't see us backing up on something
Well,
like
and
that.
this
You
is-
tell us- wait a minute, it's easy to say, I don't remember one case from another.
No,
So
and-
I don't remember that we fined this guy $50 last time, we're only gonna fine him 25.
Correct. And-
If you make the point, I don't think anybody's gonna sit here and go, we're gonna give him less because he ignored us. So
Right.
let's be reasonable
No,
here.
I am. And this is another reason why I want to segue into the guilt penalty aspect, because it's much easier for me to cover and say, ladies and gentlemen of the board, because we do mention they're a repeat violator. So there's a trigger in everybody's head. If they're a repeat violator, you've all found them.
Steve, you
Yes, sir.
tell us how much we fined them the last time, and I guarantee you, there's not anybody here that's gonna say, well, now that they've ignored us, we're gonna give them a break.
Right. And this,
So let's be fair about that.
I am being fair. And the reason why, the only reason why I'm bringing it up is because if you hear that, that's the nexus it's
Good.
coming from. But I never felt comfortable presenting it during the hearing to say, well, 3 months ago, you found him guilty of this and you charged him $100 a day, but he hasn't mowed his yard. It's that separation of, is he guilty or not? And because everybody, whether you like it or not, you
Can
can
I
try
ask
to
you a
remain
que-
as
Tom, in your
partial as you want,
experience-
but it's hard.
Excuse me, but in your experience, would that cause any problem for the officer to mention it?
Well, the crazy thing about it is that the statute, when it says that you are to establish the fine, there are 3 criteria. And when it talks about those 3 criteria, one of them is, have there been any previous violations? And so you are to consider that and determine the dollar amount. I understand where Steve is coming from, and it's probably the smarter way and legally better way to do it. But I have not seen in my 30 years of doing this that, and the next case may be the first one, but I've not seen that to be a big issue. But if that's the way Steve wants to present the case, that's his case. He can present it that way. And and again, it's probably a better legal way to do it so that you can avoid one additional legal or technical argument. But I have not seen it to be a problem.
So if we get the flyers that we get every once a month, it tells us each case we're going to hear, and it says it's a repeat violator, why not include fine $100 previously? Can we do that on that? This
You
way,
should-
they
no.
don't have to know about it, but we do.
No, you shouldn't be doing that, and for one reason only, because you were to make your determination as to that fine based upon the testimony and evidence received at this meeting, not
Previous.
evidence that you've received prior to the meeting. And that would be considered some type of evidence as a dollar amount, and it's factual, but it's prior to the meeting. You may have read the agenda, but Jerry may not have. So now you've got testimony or you've got evidence that you're considering to do your dollar amount of the fine, but Jerry doesn't have that same evidence. So I've always hesitated in having a whole lot of information on the agenda other than maybe the case number, the property owner, and the actual violations being alleged. So
But if it's presented at the case, you don't see a problem there.
he's going to present it one way or the other. We've been doing it in the beginning of the case, and at this point, he's suggesting that he does it on the back end of the case. That's his prerogative in presenting it to you. But I have not
guess
seen it to be a problem.
All I'm saying though is if we know that somebody had gotten fined $100 and now they're back as a repeat violator, reasonably, I don't see anybody saying, "Oh, well, we'll only charge them 25 this time."
Yeah,
Exactly,
So I
Carl.
don't see any problem with
But
you.
if you don't
No, and that is the exact reason why I want to separate the guilt and penalty aspect, because the guilt is very simple. I went out here, I took pictures, here's his yard on this date, here's his yard on this date. Here's my yardstick saying it's 26 inches high. Here's all my notices I sent him. He was the right guy. He sent the notices back. He said, I know, screw you, have a great day, whatever. I'm not mowing my yard. It's my grass. I love grass, or whatever the case may be. You all decide, well, you're guilty of it. Then I say, this is the 14th time we've been out there, and Mr. and Mrs. board members, you've heard him 6 times, and the last time he was here, you established him, and you established a fine of $100 a day.
I think
I'm
that's great.
asking now for a fine of $150 a day, and so on and so forth. I feel much more comfortable presenting that. And like I said, I think that goes back to my criminal side. You would get objected to immediately as soon as you tried to bring up his prior history.
I think that's good for us as the board, my own self speaking, that now we have guidelines. We have found the person guilty. Now we can go back to what you have in your report and base our decisions. Yeah, we found him guilty 3 months ago, found him 100, and then we'll go ahead and go ahead and do it that way.
Yeah,
It gives us guidelines.
And what I'll do, you guys get some of those administrative documents at the end as a last exhibit, and a lot of times they have the prior cases in them, and I've always felt a little weird passing that out in the body of the case. So what would happen is at that point, you find them, I'm going to say, okay, I'm going to present my last documents. It shows his prior cases. It shows the last case on this date where his fine was X number of dollars. So you guys can make an educated, impartial, and
As long
informed
as we
decision.
have that information before we set the penalty, then
Yes, and Carl, you know, the examples that happened before were the learning curve for me. And I think it was, you guys weren't provided the information. I didn't necessarily know you were not provided the information. And it's not a slight or a down on anybody. It's just trying to have everybody kind of on the same sheet of music.
On the
and
same
it
page.
leans a little bit more towards impartiality, especially on that board review, because if you get the one guy who comes in and the exact same circumstances between person A and person B, and you find them exactly the same and it's $150 a day, no problem. You present the exact same circumstances. One person is maybe dressed nicely and is tall, and they get charged $20 a day, and the next guy's the exact same circumstance, and maybe he's not dressed so nice, and suddenly he gets charged $150 a day. You may run into, at some point, I've been told that it really doesn't matter, but the court of public opinion, unfortunately, we all work for. And I would sit there and go, well, that's kind of messed up. Person A and person B.
And
And there's no
done
history.
That, we've
So-
done that ourselves.
And I'm just trying to make it a little clearer
Yes.
and a little easier. And to decide guilt is very clear on the table. That's all the evidence I'm going to present to you is here's the facts of the case. Nothing else. None of his prior history. How many times have I seen this guy? I'll cover due process. I sent him 14 letters for this offense, and I did this, that, or the other thing. That's it. That's just part of covering due process. And here's the pictures, and this is when I took them. And this is the ordinance that I'm citing him under. You guys decide.
Can I raise a question, Tom, and ask you this? I've been on this board for almost 4 years now, and it seems the most reasonable of boards I've ever been involved with. What's our record? We don't ever see any cases that end up going to a court, or I would think that we have a pretty good record as far as our decisions have been supported, unless I'm completely misreading things.
No, you have a fantastic record, and I haven't really ever calculated it out, and I would need some help from code enforcement. But maybe for every 2,000 cases, maybe one would appeal. I mean, it is so out of the ordinary for there to have been a case that has
Well,
been
let me see
appealed.
if I can reach back.
You
We
guys
can
did
pat
just
each other
have-
on the back.
Good, you should.
You guys did just have one, and I don't think I can discuss it. I don't know, but there was an appeals case that just came through, and it was one of my cases before this board. So I don't know if it goes along the 1 in 2,000, because that puts me at about 1 in 20. So
We're good.
that
You're
may
not
be an
good.
issue,
Okay.
but-
We're good. You're not. Okay.
Yeah, and that case taught me a lot, and that's when a lot more evidence started to go in, because that's when I found out what's reviewed, and it's very important. The only thing we can do here is preserve the record, and I'll actually I started saying it like the last time. Well, Mr. Chairman, my purpose is just to preserve the record and get it on the record, because that's what the court uses. So with that being said, look at this. I almost did it in an hour.
Damn.
For you.
It's amazing, isn't it? I think I about covered everything that I wanted to cover. I really appreciate you guys letting me do this. I want to keep everybody informed. I don't want to just suddenly, I know it was weird when I started to present all the evidence and I tried to give you a little heads up, but like Tom said, it's not a good forum to do it with an audience of people and go, hey, we're changing how we're doing everything today. In about 5 minutes, you're going to be completely confused. I'd rather do this, and me personally, as board members roll in and roll out, I almost think this should be a once-a-year thing, just to get together and see where everybody's at. And if you have questions of me, we do have issues because of the sunshine law. Obviously, we can't discuss any cases. Procedurally, we're okay on talking about these things. I'm always going to refer back to Tom because I'm never going to, he protects you, he doesn't protect me. And he's going to make sure that I don't give you any information where he's going to veto it. And I say anything out of school. And hopefully I haven't done that today. I've tried to do a little research. I provided you guys with some homework. If you really have sleeping issues, this is a really good statute.
To read, to go to sleep.
Read, and it'll put you out. I know, Tom, this is your world, and like I said, I've read through it, and it's actually one of some of the better. I didn't include the second aspect of this. There's a part 2 to this whole statute, and it covers the notice to appears and things, and it's a whole different world because those go to circuit court and stuff like that. That's another thing that I handle. You guys never see. I write notice to appears into criminal court for ordinance violations as well. Perfect example is solicitation stuff. Doesn't come before the code board. I catch them in the act, I cite them on a notice to appear, and they go into county court, and they're handled there. Every code case I have potentially could be heard before a judge, and I could, I want to say circumvent, but based on the media that I use to present the case, it would skip the board and go right to a circuit court judge. So there's still a lot of cases on top of that 52 that I have. I have a couple right now that Tom's office is handling to go to circuit court that are ordinance violations. So it's kind of a dynamic world, and I, like I said, I really appreciate you guys doing this. I know, like I said, I hope I didn't insult anybody's intelligence or anything like that. I just wanted to. It's interesting stuff. After 24 years of law enforcement, I'm still a police officer, but this is I felt like a rookie cop when I sat down in code enforcement and started to read through this stuff. It was a world I just never touched before. And I lived in the city for many years, and it's a significant impact on what we do for everybody. And I think it's very important, and I appreciate all you guys' hard work and understanding of me.
I'd like to commend you because, after what Tom said, that most cities around here only react to phone calls, and where you go around and basically look after our city for us, I have to say thank you, and I commend you for your efforts. Really.
No problem.
Good.
I at some point in time, probably in one of those crazy classes, I heard somebody say that it's easier to go ahead and follow up, because I went and took all my cases as soon as I sat down, every single one of them that was in fine status, that was drawn a daily fine. And I pursued every single one of them to see if I could get them into compliance, because I don't want anybody to be not in compliance. And just so you all know, and it's not an issue, we just secured a contract for abatements for landscaping. We have a few properties in town that I can finally get mowed. We had no contract. We had no bids. We had no anybody that I could go send out to mow yards. So I'm going to be able to get a few of those taken care of. That all just came into place. That's one of the things, like I said earlier, you guys can order those things. I think the way we do business is very good as it is. I just wanted to present the other aspect, especially with the guilt penalty aspect. I think it makes life a little easier, and to introduce these extra or the costs to be reimbursed to the city. So again, I appreciate your time, folks. And at this point, unless you hear, you'll get official notification if we cancel January, but I have a feeling that's the direction it's going to go right now. Because like I said, I don't have a clerk, and it's going to take a little bit to get one as good as Sue. Yeah. So,
The only quick
but I appreciate
suggestion
it.
I'd make, excuse me, is that we do have some change in the wording, so.
The motions.
On the motions.
Yeah, I just would be more comfortable knowing, okay, here's what I say on the guilty part, and now here's what we say on the penalty part.
Okay.
And before I adjourn, is basically everybody on the board in agreement with what Officer Gaston put out today? Okay.
Yeah.
All right, okay.
Thank you.
Thank you.
Thank you.
Have a great day.
It's 3:02. This work session is adjourned. Oh, and Merry Christmas to everybody.
Merry Christmas.
Merry Christmas and have a Happy New Year.
Hanukkah, whatever.
Or Happy Hanukkah. Yeah, I don't want to offend anyone.
Kwanzaa, whatever.
Yeah, Kwanzaa. Bobby, do you need all the stuff taken in? the name microphone, name?
I'll pick up the plates, but the microphones stay,
All
so.
right, I'll get the pads of paper.
Yes, sir, I'll pick them
All
up
right,
too.
okay,
Thank you.
I'll get
Take this. And if you want, scan it and just email it to me, but you probably might want to update your contacts as well.
I have all of them, honey, but I don't think Miss
These were ones
Allen.
that didn't get Michelle's email.
Really? She said
Yeah.
okay, I'll double check with her and I'll send it back to you after we verify, okay?
Actually, I have a question for you. Last month, my daughter was in the hospital, so I didn't come to the meeting, but I called the code enforcement and left a message. Is that a good way to let anyone know if I can or can't be?
Yes, yes,
Okay.
please always contact code enforcement, they're the ones that will be, they usually notify me, you can, it's just easier to do one person. When Miss
Yes,
Susan
sir.
plays.
It sounds like a
Anyway, yes,
plan.
it's fine. As you know, it has, if you read the bylaws, you can't miss 3 consecutive meetings, that's all. I mean, people get sick, people forgot things,
Yeah,
you know.
my daughter's still,
I'm sorry to
I
hear
got
that.
someone to take, I got my mom to watch her.
Aw, how old is your daughter?
Well, she's 28, but she has, spinal cerebellar syndrome, ataxia, progressive brain disorder. So just having a rough time.
I hope her well. You have a good Christmas.
Thank you, you too.
Thank you.